there everyone, welcome to Edupedia World Computer Applications 9th grade video lecture series. I'm Upeka Vandibona and today we are going to start the third section, Computing and Ethics. This episode is for intellectual property rights and under that we are discussing patent and trademarks. So what does it mean by intellectual property? Intellectual property refers to creation of the mind, inventions, literary and artistic works, and symbols, names and images used in commerce. That's how the WIPO, World Intellectual Property Organization, described it. It is the main organization who took the initiative to protect intellectual properties internationally. We will discuss them about in the next episode. Intellectual property is divided into two categories. First one is industrial property and the second one is copyrights. Industrial property includes patent for inventions, trademark, industrial designs and geographical indications. Copyright covers literary works such as novels, poems and plays, and then films, music, artistic works such as drawings, paintings, photographs and sculptures, and architectural design. Rights related to copyright include those of performing artists in their performances, producers of phonograms in their recording, and broadcasters in their recording and television programs. So now we know what is intellectual property. Then what is intellectual property rights? Let's discuss about that. Intellectual property rights are like any other property right. They allow creators or owners of the patents, trademark or copyrighted work to benefit from their own work or investment in a creation. The importance of intellectual property was first recognized in the Paris Convention for the Protection of Industrial Property and the Berne Convention for the Protection of Literary and Artistic Work. Both of these treaties are administered by the World Intellectual Property Organization WIPO. Now you may wonder why such kind of a preparation, such kind of a structure to promote and protect intellectual property. There are several compelling reasons. First, the progress and well-being of humanity rests on its capacity to create and invent new works in areas of technology and culture. Second, the legal protection of new creations encourage the commitment of additional resources for further innovation. Third, the promotion and protection of intellectual property spurs economic growth, creates new jobs and industries, and enhances the quality and enjoyment of life. All what it means was the intellectual property system helps strike a balance between the interest of innovators and the public interest, providing an environment in which creativity and invention can flourish for the benefit of all. So now we are moving in to discuss about the first intellectual property protection mechanism, patent. So what is a patent? A patent is an exclusive right granted for an innovation, a product or process that provides a new way of doing something, or that offers a new technical solution to a problem. A patent provides patent owners with protection for their inventions. Protection is granted for a limited period, generally 20 years. So now I'm going to answer a few frequently asked questions. First question. Why patents are necessary? Patents provide incentives to individuals by recognizing their creativity and offering the possibility of material reward for their marketable inventions. These incentives encourage innovation, which in turn enhances the quality of human life. Second question. What kind of protection do patents offer? Patent protection means an invention cannot be commercially made, used, distributed, or sold without the patent owner's consent. Patent rights are usually enforced in courts that in most systems hold the authority to stop patent infringement. Conversely, a court can also declare a payment invalid upon a successful challenge by a third party. The third question. What rights do patent owners have? A patent owner has the right to decide who may or who may not use the patent invention for the period during which it is protected. Patent owners may give permission or license to other parties to use their inventions on mutually agreed terms. Owners may also sell their invention rights to someone else, who then becomes the new owner of the patent. Once a patent expires, protection ends and the invention enters the public domain, meaning the owners no longer holds exclusive right to the invention, and it becomes available for commercial exploitation by others. This is also known as becoming off patent. Fourth question. How is a patent granted? The first step in securing a patent is to file a patent application. The application generally contains the title of the invention as well as an indication of its technical field. It must include the background and the description of the invention in clear language and enough detail that an individual with an average understanding of the field could use or reproduce the invention. Such descriptions are usually accompanied by visual material, drawings, plans, or diagrams that describe the invention in greater detail. Final question. What role do patents play in everyday life? Patented inventions have pervaded every aspect of human life, from electric lighting and sewing machines to magnetic resonance imaging, MRI, and the iPhone. In return for patent protection, all patent owners are obliged to publicly disclose information on their inventions in order to enrich the total body of technical knowledge in the world. This ever-increasing body of public knowledge promotes further creativity and innovation. Patents therefore provide not only protection for their owners, but also valuable information and inspiration for future generations of researchers and inventors. I hope now you got a clear idea why the world needs patent protection and how it makes the world a better place. Okay, now you know patents are granted for the inventions. So what is an invention? Remember, every invention cannot be patent protected. To be protected, the invention must in general fulfill the following conditions. It must be of practical use. It must show an element of novelty, meaning some new characteristic that is not part of the body of existing knowledge in its particular technical field. The invention must show an inventive step that could not be deduced by a person with average knowledge of the technical field. Its subject matter must be accepted as patentable under the law. In many countries, scientific theories, mathematical methods, plant or animal varieties, discoveries of natural substances, commercial methods or methods of medical treatment are not generally patentable. Now let's look at who grants patent, who have that responsibility. Patents are granted by National Patent Office or by regional officers that carry out examination work for a group of countries. Under such regional systems, an applicant requests protection for an invention in one or more countries, and each country decides whether to offer patent protection within its borders. Under national level patent systems, applicants can file a single patent application and request protection in as many signatory states as needed. So that's all about patents. Now let's move on to trademarks. What is a trademark? A trademark is a distinctive sign that identifies certain goods or services produced or provided by an individual or a company. This protection system helps consumers to identify and purchase a product or service based on whether its specific characteristics and qualities meet their needs as indicated by its unique trademark. So now let's try to answer some frequent questions asked by most of the consumers. The first question: what does trademarks do? Trademark protection ensures that the owners of marks have the exclusive right to use them to identify goods or services, or to authorize others to use them in return for payment. The period of protection varies, but a trademark can be renewed indefinitely upon payment of the corresponding fees. Trademark protection is legally enforced by courts that in most systems have the authority to stop trademark infringement. In a larger sense, trademarks promote initiative and enterprise worldwide by rewarding their owners with recognition and financial profit. Trademark protection also hinders the efforts of unfair competitors, such as counterfeiters, to use similar distinctive signs to market inferior or different products or services. The system enables people with skill and enterprise to produce and market goods and services in the fairest possible conditions, thereby facilitating international trade. Second question: what kinds of trademarks can be registered? Trademarks may be one or a combination of words, letters, and numerals. They may consist of drawings, symbols, or three-dimensional signs, such as the shape and packaging of goods. In some countries, non-traditional marks may be registered for distinguishing features such as holograms, motion, color, and non-visible signs. For example, sound, smell, or taste. Third question: if someone wants to register his trademark, what he should do? First, an application for registration of a trademark must be filed with the appropriate national or regional trademark office. The application must contain a clear reproduction of the sign filed for the registration, including any colors, forms, or three-dimensional features. It must also contain a list of goods or services to which the sign would apply. The sign must fulfill certain conditions in order to be protected as a trademark or other type of mark. It must be distinctive so that consumers can distinguish it from trademarks identifying other products as well as identify a particular product with it. It must neither mislead or deceive customers nor violate public order or morality. Finally, the rights applied for cannot be the same as or similar to rights already given to another trademark owner. This may be determined through search and examination by national officers or by the opposition of third parties who claim to have similar or identical rights. The fourth question: how extensive is trademark protection? Almost all countries in the world register and protect trademarks. Each national or regional office maintains a register of trademarks containing a full application information on all registration and renewals, which facilitates examination, search, and potential opposition by third parties. The effect of the registration are, however, limited to the country. To avoid the need to register separate applications with each national or regional office, World Intellectual Property Office administers an international registration system for trademarks. The system is governed by two treaties: the Madrid Agreement concerning the international registration of marks and the Madrid Protocol. So that's all for this lecture. From this episode, we described what is intellectual property, the patent, and trademarks. In the next lecture, we are going to describe what is industrial design, geographical indication, copyrights, and then World Intellectual Property Organization, who takes the initiative to enforce intellectual property rights. So thank you for watching, and don't forget to watch the second part of intellectual property rights. This video brought to you by edupediaworld.com. Watch more from our website.